This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
So we've covered this fundamental idea of all relevant evidence is admissible, all irrelevant evidence, all evidence that's not relevant is not admissible, unless there's some other rules. But one of the other key concepts of evidence is witnesses should only testify based on what they personally know. And what we mean by that is the witness has to have experienced something. Either they saw something, they heard something, they were part of something, they were present. And so they can give direct testimony about what they experienced. In contrast, if they're only testifying about what someone told them happened, we would call that secondhand knowledge. That's not permitted. We also call that hearsay. And most of the rules of evidence are designed to promote the truth-finding function of a trial. And this is one of those rules. We know from our own experience that if we were present at an event, we would perceive that event a certain way. And if we hear someone else tell us about it, well, then we're only learning about that event through the lens of someone else who might have a bias, who might have focused on certain things, but not other things. So we don't want witnesses to come to court and just tell us what other people have told them. We want witnesses to tell us just what they know. So this is kind of the parallel or companion rule to the hearsay rule, the rule against hearsay. Now, I should say, I think most people know that the hearsay rules in the federal rules of evidence and the American system can seem very complicated. We're not going to go into the details of all the exceptions, but we're going to focus on the core concept. And so the core concept is that hearsay is not admissible, that only evidence that's perceived, experienced by the witness is allowed to be admissible. But we will go into a little bit of detail. So what actually is hearsay? So hearsay would have to be a statement, and mostly it's a verbal statement, but it could include some nonverbal conduct. And to identify who made the statement, we use the term declarant. So that just means the person who made the statement. The declarant is somebody who is not a witness testifying at court. So in other words, Professor Carrington might tell me that the weather in Mississippi today is beautiful. But Professor Carrington is not the witness in court. I am the witness. I will not be allowed to testify about the weather in Mississippi because I have no personal knowledge about the weather in Mississippi. The second part of this is the statement has to be offered to prove the truth of the matter asserted. And this is the part that sometimes gets a little complicated. So let's say for some reason the weather in Mississippi today is an important matter in a case. I could not testify about what the weather is. But if the issue is, has Professor Carrington talked about the weather, I could testify that yes, Professor Carrington talked about the weather because I do have personal knowledge about whether Professor Carrington talked to me about the weather. I could testify about that. And it doesn't matter if it's a sworn statement or whether it's an investigator's memorandum of the interview. That witness has to testify in court. that's the only way they can provide the information that's contained in the witness statement. So we're not allowed to use written statements taken before the trial as a substitute for the live testimony of the witness. And the only real exception to that would be if the parties agree. Let's say the prosecutor and the defendant agree that if the witness were called to testify, this is what they would say. There's no dispute about that. But unless absent that agreement, which usually doesn't happen, that witness must come to court. I want to talk about another very specific example that commonly occurs in criminal cases. Here I've used the phrase, the defendant's post-arrest statement. And I use that intentionally because sometimes the defendant, after they're arrested, makes a confession. They admit that they committed the crime, or they admit that they were present and may have participated in some of the criminal activity. But sometimes the defendant, after they're arrested, denies being involved in the crime. So their statement is not a confession. We would just call it a post-arrest statement. Now that's similar to a witness statement. It's written down. Sometimes it's signed by the defendant. Sometimes it's a memorandum prepared by an investigator. So it looks like a witness statement. But according to our rules, a post-arrest statement by a defendant, when it's offered by the prosecutor, is not hearsay. So this is where sometimes people get confused. It is an out-of-court statement, and it's offered for the truth of it. But when it's made by the party opponent, the defendant is in court. The defendant has the opportunity to cross-examine the witness or to testify and dispute what was in the statement. So under our rules, a defendant's post-arrest statement, if it's offered by the prosecutor, is always admissible. So I make this point because many cases, not all cases, have confessions or post-arrest statements. And it's not difficult for them to be admitted into evidence, even if the defendant does not testify. Now, sometimes the defendant in their post-arrest statement doesn't confess, and they give some explanation or some alibi or some defense. Now, if the defendant offers that in evidence, it's not admissible. And why is it not admissible? It's because the prosecutor doesn't have a chance to cross-examine the defendant. And so if the defendant wants to put in a defense of an alibi or some other explanation which is contained in their post-arrest statement, they might have to testify or call other witnesses to put that evidence into the trial. The other category of statements that commonly are found in criminal trials are statements that are not offered for the truth of them, but for the fact that the statement was made. So one example in the bank robbery case is if the bank teller testifies or is asked, what did the defendant say to you when he was in the bank? That's an out-of-court statement. The teller can testify, well, he said, give me all your money or I will shoot you. So the fact that the defendant said that is relevant, even if he had no intention to shoot the teller. So that's a statement that's not offered for its truth. It's offered for the fact that it was said. And the fact that it was said is, of course, very relevant in a bank robbery.